Okay, I think we'll make a start now. Good morning, everybody. Thank you all for joining us this morning. This is the first of three short webinars that we're running between Mazars and Mills and Reeve. The first one today is going to cover sort of PCN issues, and we will touch on PCN Incorporation and what that actually means. Our second webinar was in a week's time, when we're going to start to talk about practice mergers. Because they are coming more to the fore in general practice, we're starting to see those pick up again. So quite a few issues to cover there. And then our third one is towards the end of this month, where we're going to just have a general legal update, and accounting update. And it should be post the financial statement as well. So if there's anything that comes through on that, we will we'll cover sort of issues that relate to general practice through that. My name is Andrew Pow. I'm a director in the healthcare team at Mazars, accountants. So we do accounts, tax, pension planning, and everything to do with general practice. And I'm joined today by Rob. So Rob, if you'd like to introduce yourself.
Yeah, morning everybody. So my name is Rob Day. I'm a partner at Mills and Reeve, solicitors. So well, myself, I'm head of primary care team at Mills and Reeve. So we support practices, those that are very small to those that are very large, and all aspects of their business.
Okay, thanks, Rob. So in terms of today, if we can just move on a slide. What we're going to cover. So I'm going to sort of deal with some of the accounting issues. So we're going to look at accounting records, how we recognise income and tax, and the problem area around PCN surpluses. We'll talk a little bit about VAT and also about the clinical director role as well. Rob is then going to move on and look at some of the legal issues, and some sort of topical ones that are beginning to come to the fore. Unfortunately, as PCNs have evolved, we're starting to see some problems start to occur. So we're going to talk about how to remove practices from your PCN. He's going to look at actually whether you could withdraw from the PCN and what the issues affecting your practices are. And also boundary changes with the ICBs coming and ICSs coming into being. We're again seeing a lot of things start to move in that area. And then we'll move on to the incorporation side as well, and just touch on some of the issues incorporation brings, and some of how it unlocks some of the problems. So if I'm going to kick off really with the accounting side of things, so we just move on to the next slide. We're seeing a number of accounting issues occur within PCNs, and partly it's because of how they evolved, and we have to sort of go back to how they evolved in the fact that NHS England set them up as a DES. So they didn't set them up as it wasn't a separate contract. It was just an add-on effectively to every GP practice's contract as a DES. And that created a problem of having an organisation which was meant to work together, which had its own resources, but actually all those resources were being diverted effectively through someone else's contract. So from an accounting perspective, I think one of the most important things is to remember that actually GP practices are very, very clear with their accounts. They have to be produced, they have to be submitted to HMRC, but there is then a legal requirement of the PCN also, because effectively the PCN is an add-on to that account, that they have to account for their income. We'll come on to the sort of surplus side of things and recognition of income in a second, but I mean the second point is around probity, and I think it's a really important issue in that, again, as the size of the money that is going through PCNs has grown year on year, it's really important that you have visibility through your PCN as to where that money is being spent. We see too many PCNs still at the moment who really don't have good internal systems, and aren't able to, can't press a button to see where they're up to. And that often then leads towards the end of the year when there's money sat in the bank account of disputes are really how to deal with it, how to spend the money, how to distribute it back to practices. So the probity side is really important in terms of having accounts open to you. There isn't any prefix format for your accounts. Obviously, as advisors, we can set out what we think you need to have, but there's no legal requirements as to prepare accounts in a certain format. But we certainly think that some form of accounting summary should be performed year on year. Just in terms of the surplus side of things, it's worth touching on the surplus. One of the most important questions we get from time to time is, how do we deal with a surplus? When do we pay tax on it? And it goes back to the fact that the PCN is an add-on to your GP contract. under the way it works effectively is tax has to follow what's called UK GAAP rules, and GAAP being generally accepted accounting practice rules. And that really sets out how you recognize income and how you recognize expenses. And basically income has to be recognized when it's earned as a service or when you provided the service. Okay, so really from a PCN perspective, the majority of the income you get in, so CD monies, management monies, etc., they are earned really on receipt. You can put a provision into your account for future costs, but basically you can only put a provision in for tax purposes if you've got a legal binding, so obligation for future costs. So you can't put a provision in simply for tax purposes to say, look, we've got £100,000 in our bank account which we've made from COVID vaccines, and we want to spend it next year on a a nurse project, because that's not actually linked to the COVID money. The COVID money was earned, and the expense is completely separate. The only expense you can really properly provide for from a tax perspective is ones where there is a condition to spend that money on something, or a condition that if you don't spend it, it has to be returned to commissioners. So that does create a timing issue in that you get income in one year and maybe expenses in other years. But it doesn't get around the issue that actually you have to pay tax on the income when it arises, and most of the expenses you get tax-free when you expend them. So that has created a point of tension in terms of tax being paid on income practices don't have. From a VAT perspective, I think we've gone over this time and time again. VAT is really problematic because of how it's been set up. And essentially the difference is because I think when they set up PCNs, they assumed actually the nature of PCNs was a supply of medical services or welfare services, which are generally exempt from VAT, so outside the scope of VAT. But actually they didn't really create that situation. What they created was a situation where one practice gets the money, one practice employs the member of staff, and that member of staff then goes and works out in multiple practices. So actually it's potentially a supply of staff. And the difference is supply of staff is VATable if you don't get it right. So you've always got to consider VAT from the practice viewpoint and from the viewpoint of the people that are employing the members of staff. And you have to look at what they are doing, who controls them, and where they're working. It's not, you can't just simply rely on the fact that actually you've got a pharmacist here, pharmacist doing medical services, therefore is exempt. Actually, the situation is practice A employs a pharmacist and supplies that pharmacist out to other practices. So that's a really sticky issue at the moment. And to be honest, a lot of lead sort of practice model PCNs really aren't compliant with VAT at the moment, unfortunately. You can get around that through something called a VAT cost sharing exemption. We'll come on to this a bit further on in the incorporation as the rules behind that, but that works very well with federations. It works very well with a limited company PCN because they are separate organizations which sit in between the practices, which is a requirement of the rules. And you can avoid VAT essentially when you're just sharing costs via that route. But it has to follow the specific rules. And it's quite important if there's anyone on this call from federations that they actually are reviewing their internal structures to make sure they comply with these rules. And the other one, single practice PCNs, they're the easy one in the fact that they actually don't have to worry about VAT because all the money just comes into the practice, used by the practice, it's not going anywhere else. So they're the simple one, really. The last sort of accounting issue is around PAYE and clinical directors. Just this has been ongoing with HMRC really since they came into existent PCNs, and the HMRC weren't particularly helpful in the fact that to start with they didn't really understand PCNs. They didn't really understand what the clinical director role was doing. And they did originally sort of come out and say, oh, in fact, they've all got to be under PAYE and they should be on a payroll. But since then, they have sort of looked at various scenarios. They're still coming round to the view that the majority of clinical directors are effectively officers. And the reason why they are officers is they are appointed by the PCN to provide that role. Through the PCN documentation, and because they are officers, HMRC's viewpoint is actually really they should be on payroll under PAYE. To date, to be fair, they've been very light touch about it. They haven't really been bothered too much because most of the tax is being collected in one way or the other. The difference really between self-employment and employment is around employers' national insurance. So potentially there's a lost cost of employers' national insurance if you're being treated as self-employed. So it's an ongoing issue really, and I think every scenario has to be looked at individually. Quite a few federations are paying CDs through a payroll, so that's fine. It's more, again, the more looser structures where it perhaps is on a self-employed basis, which will become more to the fore in terms of HMRC looking at it. So these kind of issues are now, they've been around a couple of years, but they are coming to the fore really because the size of the PCNs are growing quite significantly. So that was really just a very brief run through some of the accounting, VAT and PAYE issues that we're seeing. I'm going to hand over to Rob now, and Rob's going to take you through some of the legal problems that we're seeing.
Yeah, thanks, Andy. So what I thought we would do on this particular section is cover three points, and they're points which historically were not really considered. They do, however, seem to be materialising as bigger problems now, only in the sense of where you're considering this. Actually, the fundamental point or rationale behind considering this is quite a significant one. So the first point we wanted to cover on the legal considerations is the point around removing the practice. And interestingly, when we've dealt with this as a possibility, we've looked at this from both angles, so both from a provider perspective and a commissioner perspective as well. And on both counts, I can say it's certainly not straightforward. So when it comes to removing a practice, and it's worth saying that really this was more of an afterthought when it comes to the network DES than something that was pre-planned. But it's very specific, and that's the point where you need to look at. So the DES itself is the contract, just like any GMS or PMS or APMS contract, with specific terms. So if you're looking at what you can and can't do in connection with your PCN, then the DES is the starting point. So when it comes to removing a practice, the DES is very explicit. So practices can be removed in one of three scenarios, as I've mentioned on that slide there. So where their core contract expires or terminates. So let's take an example. So where a practice holds an APMS contract, that contract comes to an end, then that member will automatically be excluded from a PCN, from a network. The second point, and it's one which causes the most amount of confusion, is there's the ability to remove a practice where there's a irreparable breakdown in relationships, or where they're looking to expel a member from the network itself. And the last one there is there's the ability to remove a practice, and I caveat this to say it's the ability to remove it, but it's actually following the lead of your ICB. It's where the practice breaches their obligations when it comes to delivering the DES, and there's contract management by the ICB, which leads to their participation being terminated itself. So yes, it's still removing a practice, but it's still the ICB that would take the lead on this. Now, what I think I would stress when it comes to removing a practice is that the ICB always needs to be involved. So your commissioner will always need to be consulted with what you're intending to do. And they will always be looking at what the viability of the network's like after the proposed steps take place. So in essence, what they're looking at by reference to viability is whether it satisfies the core criteria for the PCN to actually be set up as a network in the first place. So I've written those on the slide there. So we're talking about the patient population it serves, and that's usually the biggest thing that it looks to consider, because it's usually a case of where you're removing a practice, actually it brings the number of patients within the network below that 30,000 threshold. Now that's not absolutely terminal, to the PCN surviving, but we're seeing ICBs taking a much more harder line when it comes to that sort of patient population. But what I would say, and what the takeaway is the ICB will always be considering this. You can't do anything unilaterally yourselves, and what they will always be looking at is actually whether this is the right thing to do for the system, not necessarily whether it's the right thing to do for the PCN. So with that in mind, I wanted to touch primarily on the relationship breakdown and expulsion point. So yes, it's allowed, it's provided for, but it's not straightforward. So what I've tried to do is within those circles which are on the slide is really give an indication of what you need to do if you're considering this for any of your member practices. So the first thing to do is you need to check whether you've got the right to remove a practice from your PCN. So what I mean by this is any primary care network is a contractual joint venture between its member practices. And therefore, what you need to do is look at that contract, the contract between the member practices, to see whether you've got the right to remove an individual member. Now, it's much the same as if you had a partnership agreement, you'd be looking at the expulsion rights for your partners. But it's imperative that you check that you've got the right to do so. Now, in checking that right, you'd be looking in two places. The first is the mandatory network agreement. And the second is your schedules to see if there's anything which is supplemented within the schedules, which give you a broader right to expel or remove a practice. If you've got that right, and that has to be ticked, you then need to go to your ICB. You need to give them prior notice of your intention to either expel or to remove a member from your PCN. It's then really with the ICB will go away. They have an obligation to discuss the proposals with all members within the PCN itself. And then again, it will consider the viability of the network if that was to take place. And ultimately, it's on the ICB and it's at their discretion as to whether they will agree to the removal of a practice. Now, in our experience, what they're looking at is whether they could house the practice elsewhere in another PCN. But the problem always is, you don't remove a practice for no reason. They're usually quite disruptive practices within the network itself. So the reality is how likely it is that they're going to be able to house them elsewhere is slim, because no one really is going to want to actually take them on. Now, there is a process where the ICB can say, actually, we've gone through this mechanism, we've gone through this process, and actually we can no longer find a home for you in another PCN, and they'll leave them as something called an orphan practice. That's what they get referred to as. And in which case their patients will be seen by a PCN, but they won't actually participate in one themselves. But the circumstances where that applies are very rare. As I said, most ICBs take the view that they're trying to resolve these disputes as opposed to sort of pushing ahead with decisions to remove or expel. Moving on, Harry, there's some questions in there. I can't see the questions at the moment. If there's anything related to that, Andy, do you want to shout out and then I can answer?
Yeah, so Rob, there's a question specific to this of can an ICB force a practice onto another PCN against their wishes?
Technically they can. The reality is I've not seen them do that. But yes, if they really wanted to, they've got the ability to assign a practice to a specific PCN. Right, so the next one is around the right to withdraw. So this should be quite a quick one, and it's just probably a recap for anybody that's sort of looking at their network and the DES itself. So the DES is an annual contract, and it's something to bear in mind. It runs on the 1st of April, to the financial year, effectively. And how the DES operates is it operates as an opt-out arrangement. It didn't initially when it was first put in place in 2019, but it is now. So what that means is all practices that are signed up to the DES are automatically signed up for every new version, every variation of the DES year on year, unless they opt out. and they can only opt out in a limited number of circumstances which are written there. So in essence, there's two opt-outs available. The first is that you opt out the DES. So once NHS England identifies what the new specification is for the DES itself for the following year, it will indicate a time frame where practices can turn around and decide whether to withdraw. So if you take this year's one, for instance, it was the end of April that practices had the ability to opt out. But in the following years, you just need to look at the DES to see what that opt-out window is like. It's specific in the DES itself. The other one is where NHS England looks to make mid-year variations or changes to the DES specification itself. In those scenarios, practices have 30 days in which to opt out after being made aware of what the variation is itself. So they are the two circumstances where, you know, a withdrawal is possible. Now, there is in-year participation, ability to be ended, but that's not really seen as a withdrawal. So I've referred to the circumstances where you can end your participation. We've mentioned it before, so there's expiry, termination of a core contract, expulsion, relationship breakdown, where the ICB approves a merger or a split of the PCN. So for instance, the ICB approves a merger, and what happens as a result of that merger is practices then either form one PCN or look to form one PCN, or they split, and what happens is you have a situation where one of the practices will be or become a member in one PCN, and the other will look to migrate somewhere else, which is more geographically coterminous with practices in their locality, or where the ICB ceases the practice's involvement in the DES itself. So again, through contract management, it's taken the decision to terminate their participation. So Harry, can we move on? Right, so the last legal consideration before we get into incorporation is around boundary changes. Now, really, the upshot of this is you can't really make any boundary changes unless the ICB approves it. And it is a very difficult process to try and get approved. And the rationale behind that is that the ICB clearly has its own geographical patchwork of PCNs that need to work coterminously with each other. So what it doesn't want to find is a situation where boundaries start to cross over with other PCNs. Now, there may be a situation where it's actually deemed to be a positive and a well thought out variation. But in those scenarios, what's going to need to happen is if you're going to propose a boundary change, you're likely not only to need the ICB approval, that is a definite and it's at their discretion, but you're also likely to need to involve another PCN, because where your boundary moves within the network, you're undoubtedly going to be encroaching on another PCN's boundary as well. So it's not just a case of going to the ICB, it will involve other practices and other PCNs as well. Now, when it comes to what those boundaries look like and if it's going to be considered, the ICB will be looking at those core things when it comes to the boundary area. So what they'll be looking at is that it's sustainable for the future. In essence, what that means is that it works when it comes to what the future commissioning plans are for the locality. It needs to align with the footprint of the ICS strategy. It needs to make sense to the practices, to community-based providers and the local community. And then there's the geographical coterminous arrangements there. What they don't want to find is that PCNs A, cross over each other, and B, to the fullest extent possible, do not cross commissioning boundaries. It is possible and that can happen, but what they try to do is avoid that if at all possible. So next slide, I think we're back on to incorporation. So Andy, I'll hand it back over to you.
Yep. So the sort of second part of our talk today is really around the incorporation side of things. Whilst this is not new specifically, it's becoming more to the fore again as PCNs develop in their maturity. really sort of some of the key issues and some of the key questions that are always asked are those shown on the screen there. The bulk of the activity or biggest issues around staff employment more than anything that we have, and because of the way PCNs are set up, you have the situation where staff may be employed by a PCN lead practice, they might be employed by a federation, and there's always someone who sort of sits in between the PCN board who are controlling things and who's ultimately employing the member of staff. And that can create tensions. It can create a feeling from those staff of maybe not belonging to the organization. I had a question raised the other week by a PCN just about Christmas parties, about whose Christmas party should the PCN staff go to, because there isn't actually an organization. And it's incredibly minor questions like that, which actually are really important to people. So, it's the incorporation is around potentially a way of actually looking at having a more robust structure around employing staff directly. Liabilities is an issue. Whilst NHS England have said that, if PCNs come to an end, once this 5-year contract period comes to an end, those staff will transfer on to another organisation, and the PCN ARS staff are still going to be employed by someone. There is still a risk in terms of employment liability. But there's also liabilities. As PCNs expand, you are providing more and more services, and eventually, as the ICB side of things develops, potentially they're going to be the vehicle for having services contracted down to primary care, and with that comes contract liability. At the moment, because again it's a DES is attached to the GP practice. The majority of GP practices, not all, but the majority are at the moment still unlimited liability partnerships. There is ultimate contractual liability risk that falls down to the GP level at the moment with the structure. VAT is an issue. As I said, the transfer of staff from practice to practice creates a VAT liability potentially. And the issue there is if you are then required to register for VAT and charge VAT on the staff cost, effectively you're losing 20% of your budget on staff, because that's going to have to go towards paying VAT. And we want to avoid that. The money is there to be spent in healthcare, not to go back to customs and excise. And it's unlikely that HMRC, even sort of in the post-Brexit environment, are going to do anything to change VAT directly within healthcare immediately, because it implicates on all kinds of businesses. Everyone always says, well, can't we just make this whole thing exempt? The problem is, this applies to education, it applies to general businesses, everything is interlinked. So by changing one part of the VAT legislation, it's quite difficult to specifically target it at a specific sector. But the incorporation route gives you an opportunity to do that. As I said, the federation route does as well. So it's not different from the federation route, but the incorporation route allows you to solve the VAT problem. And then we then do have this sort of growing competition, effectively growing between what activities should be provided at practice level and what activities should be provided at PCN level. And there are some clear benefits at PCN level to do things at scale that can be done across all practices without replicating them, but it risks also then intermixing with actually a practice has its own views on what it wants to do and may want what its contracts what contracts it wants to bid for. So we've got this sort of tension growing within PCNs and practices at the moment. Again, by going down the incorporation route, it gives you some clarity as to actually you've got a legal entity providing the PCN activities, which has set out what the rules apply to that limited company, which makes it very, very then clear as to what the relationship is back with the practices. So these are the common issues we are starting to see, and the common tensions that we're starting to see. So it is around, the incorporation side of things is trying to deal with all of those problems. So I'm going to hand back to Rob, and Rob's going to go through the pros and cons.
Thanks, Andy. Yep, so quite a busy slide, but what we wanted to do is give as much as we can a balanced view around the concept of incorporation. So on the pro side, some of these are obvious. It's got a limited liability wrapper. Now, there is a caveat to this. So obviously, if you If you set up a company limited by shares is a company that we ordinarily look to set up for PCN Incorporated organisations. But if we set that up, then it has a limited liability wrapper, which means that beyond its asset, what it actually owns itself, the liability doesn't creep back to its shareholders. So in this instance, to the member practices. The one word of warning with that is that applies unless the shareholders have done something they shouldn't when it comes to guaranteeing the obligations of the company itself. So if they've entered any form of guarantee, then that would need to be looked at because it suddenly blows open. To what extent depends on what the guarantee says, but it blows open that limited liability wrapper. The next point there is it's a separate entity which is capable of entering into contracts itself. So what that means is whether that's staff contracts being commissioned by the ICB, commercial contracts, utility contracts, whatever it may be, the limited company will be able to enter into that in its own right. We've touched on it a few times, and it will come on to it in more detail in the next slide. It's got the ability to be set up as a cost share group for VAT purposes. The next two is really around the potential of what it can do. So it's got the ability to provide not only additional support to the member practices, so it may provide back office functions, it may centralise maybe finance teams, whatever that may be, but it's also got the ability to secure wider contracts that may spin out of the new ICS landscape, which is materialised. And then the final point, which again Andy can touch on, is it's got the ability to retain profits year on year without necessarily having to distribute those to the member practices. On the con side, really what we have, and probably the biggest thing, is we have another level of ownership structure. So we have another level, I wouldn't say necessarily bureaucracy, but that's what it could be viewed as. So yes, you've got to set this up, you've got to administer this going forward, there's costs and there's fees involved in doing so, and you've got to run it. So, there's going to need to be meetings, you're going to need to document things. All of that is another level of ownership structure that needs to be put in place. Next one is there's a need for directors, as is the case with any company, and they have codified statutory duties. So one of the most obvious ones, which is always mentioned, is they've got a duty to act in the best interest of the company itself. And the reason I mention that is obviously that can rub when we consider that they might be representing practices themselves, or might be coming from practices themselves. So when directors actually enter into a board meeting on the company itself, they'll be doing so wearing their director's hat, not necessarily their practice hat. Next point is around handling of shares. So what's commonly the situation for companies that are set up as companies limited by shares is the shares are held by partners on behalf of their partnerships, or it may be held by individuals on behalf of their organisations. Whatever the case may be, what you have to bear in mind that is if those individuals leave or there's a change, then those shares need to be transferred. It becomes a very, very laborious task to try and retrospectively deal with the share transfers if you don't deal with it at the relevant time. And the final con is not necessarily a con, but it's just something to be aware of. It's imperative that those companies have clear governing rules. So through its articles and shareholders agreements, that's essential if you're to avoid disputes. Just speaking of, from example, I've seen federations set up, companies set up in the primary care world where they were set up with off-the-shelf articles. And it was running perfectly well. The company was doing great things, but there was a massive falling out between various different factions within the company itself. And there were no clear articles or shareholders agreement to fall back on to sort of identify what the obligations were on the directors, what the rights were for the shareholders, etc. So it's imperative that that's covered off. Now, really to end with, so there are pros and cons, and yes, okay, they're quite generic. They apply to all companies. But what I would say is that there are some specific considerations. So things that have materialised and keep materialising time and time again when we deal with incorporations for PCNs. So the first is something called, or we call priority of opportunity. So if you set this company up, who has a priority when it comes to a new opportunity within the locality? Is it going to be the company? Is it going to be the individual member practices? Now, there's no right or wrong answer to that. But what we tend to find is if there is going to be a dispute or a big falling out, it's usually around that point. So an opportunity arises, and it might be that a large practice seeks to secure that themselves, and that runs against what others thought they were actually entering into in this company itself. Next point is around the restrictions on what practices can and can't do. So sort of linked to priority of opportunity, but are there going to be any restrictions on what practices can do in terms of providing additional services, securing additional contracts, maybe competing with the company itself? So all of those sorts of things need to be considered. Again, no right or wrong answer, but it just needs to be thought through. I mentioned earlier around that limited liability point, guarantees and resource requirements. What are they going to be, if anything? Is there going to be anything that's going to be a draw on the individual member practices itself? Next point is around decision making. So where do the lines sit between what the board will be capable of doing and deciding, so the board of directors, and what the shareholders will be there to decide? Now, this is a really important point. And what always tends to happen is shareholders in GP companies that we tend to see think that they should and have a right to be involved in every single decision. That's not the case. The directors are there to deal with the day-to-day operation of running the business itself. And what you should aim to do is have absolute clarity on those decisions which are just reserved for the shareholders. So there should be a fairly limited list of reserved decisions which then need to be kicked back for shareholders to approve. Next point is around share rights. So who's entitled to how many shares? What are the dividend rights attached to those shares? What are the voting rights attached to those shares? That needs to be determined. Will it be determined by reference to the patient list size? Will it be equal? Again, it just needs to be thought through. And the last point is who can and can't hold shares. So are there restrictions on the types of entity or the types of individuals that are capable of holding shares in the company itself? So if you're asked to enter into any incorporated vehicle, I would be looking at these specific considerations very carefully. And the reason I would be doing that is it not only dictates whether I can actually be involved in it, but also it dictates and is likely to have an impact on my core business itself. It sort of walks that balance back towards actually our core business, whereas this is usually seen as something which is dealing with the sort of ancillary stuff which you do under the desk. So over to the next slide, Harry. I think back over to you, Andy, on the cost share.
Yeah, so back over to me, back onto the VAT angle. One of the reasons this does work is that it solves the VAT, or can solve the VAT side of things, if it's set up correctly. And again, just going back to what I said earlier, the issue around VAT is in terms of the issue around staff, particularly being employed by one member practice who are actually performing that activity in other member practices sites. And that can create a vatable supply of staff. But to get around this, there is a piece of legislation which is set up, to deal with the problem of businesses which predominantly are providing exempt activities like health, and it's set up in a way just so that they aren't worse off than organisations that are VAT registered, who'd be able to recover this VAT if they had to charge it. And essentially the way it works is, first and foremost, you have to have an organisation that sits in between the practices, and that organisation has to be in a limited company format. So again, the federation angle would work if the federation is a limited company, but this is a separate limited company which also works. And what it allows you to do is, it's going to be a separate entity. and that organization must supply services out to its members. So the GP practices own the limited company. The limited company provides the services, be it staff, be it maybe take on mobile phone contracts or all kinds of things, and supplies it out to its member practices. Those services have to directly be used by those members, which it obviously will be. Again, if you've got a pharmacist, for example, you know, that pharmacist will be working the practice, so it will be used by those member practices, so it ticks that box. And the really other important situation for this to apply, which is why it becomes very relevant to federations, is that for that cost sharing group to work, you can't make a profit on the costs being shared. So if you've effectively got the situation where you've got £10,000 of expenses and you're sharing it with those practices who are paying £10,000 of income, be it from their DES or whatever, back into the PCN, and that then you know, just matches the cost. Where it can fall down, particularly on the federation level, is the federation may then start to charge management fees on top, etc. And if it's not structured properly and not accounted for properly, that creates a VAT problem potentially. So the cost sharing group works well. It gets around that problem. I mean, you shouldn't just have to set up a company just to get around VAT, but unfortunately, you know, that's the problem we've been left with the structure. But it works, but it's important. It has to be a separate entity. So, you know, again, we're often asked, can a partnership do this on behalf of it? Why, you know, why can't my lead practice just set up a cost sharing group? Because it has to be a separate legal entity that sits in between is the most important thing. You know, are there any other ways of looking at this? And the other way of looking at it is really sort of the PCN, taking the PCN company forward in terms of actually what it does. Some PCN companies are just set up purely to try and get around this cost sharing and give this mechanism to allow practices to work in a more robust framework. Others are moving on really to a more fully subcontracted basis, where effectively the PCN practices are subcontracting all the PCN activities down to the limited company to provide that. And then what you then have to look at is actually that PCN company, what actually is it providing? Is it providing pharmacy services? You know, if it ticks the boxes of the VAT legislation, then actually it could be providing actually a full-blown service. All the risk lies with the limited company. The limited company has control over, you know, looking after the staff and monitoring the staff and controlling the staff. It can tell, you know, it controls where those staff go and work. In that situation, it may then sort of morph more from a transfer of staff to a transfer of a medical service, in which case the medical service is exempt. So again, as PCNs develop potentially and take on more services, they will become providers as such and providers directly of the medical services. So that will get around the VAT problem as well. So it's problematic VAT. It can't be ignored, and unfortunately a lot of times it is ignored, but this does give us a solution. So just then back into the next point is around just the sort of timeline of what needs to happen. I'm going to hand back to Rob, and the next slide, please.
Yeah, so this is our last slide, and it touches on, David, you asked a question around CQC registration. So if we talk around likely initial steps, so if we were setting up a corporate, we obviously need to incorporate the company at Companies House. Now, really before that, what we tend to have to do is agree what the articles look like and what the shareholders agreement looks like with the member practices. Once that's done, then that's usually the trigger for incorporation to occur. Once that's done, really that's the catalyst from which a lot of the other requirements can actually take place. So one of the key ones is if you are incorporated and looking to move staff, so network staff into the company itself, then you'd need to register with NHS Pensions to secure something called a determination. So it's a time-limited determination which enables the company to access the scheme for the staff, for the ARS staff or any other staff that it looks to employ. But the crucial thing is obviously until you've incorporated the company, the application form, which is fairly light touch as an Excel spreadsheet, can't be submitted. Beyond that, again, unless incorporation has taken place, you can't then really put in place anything to do with a 2P transfer. The company doesn't exist at that point in time, so how could you? And when it comes to the 2P transfer of staff, what you need to do is consult with the members of staff, the effective members of staff, as long in advance as is possible, for them to really understand what the consequences are of the actual transfer itself. Usually we work to a 1 month rule. That's not anything set in stone, but we tend to take the view that you should be looking to consult a month in advance of when the transfer actually takes place. Now, you don't need to know the specific date for transfer, and that can be a bit of a moving target, but you need to identify when you expect the transfer will take place. Again, that can move, but it's just something you need to filter and factor into the consultations itself. Next points are really around documentation that you might put in place with the company, so and the member practices. So the first one is, have you got the data governance arrangements in place which link the practices, the member practices, with this new corporate entity? So yes, you will be sharing information and data with them. Make sure the agreements you have in place, so data sharing agreement, data processing agreements, are up to date, along with your privacy policies. Next thing is considering this link between the member practices and the company itself. Now, really, that really depends on what it is that the company is set up to do. And I think Andy's articulated well today. You know, it can be set up for a number of reasons. So one thing it can be set up just to do is simply there just to almost house the staff members. Set up as a cost share group, and effectively the staff are shared, but does nothing else. Alternatively, the companies can be set up to actually deliver on the desk activities and to do other things as well. Now, in those scenarios, what you're likely to do in the latter one is have a more robust contract in place to articulate exactly what it is that the company will be providing to the member practices. Now, that can either be covered in the network agreement that you have, or more commonly within a standalone subcontract arrangement, which articulates exactly what the company will do. Now, this is where CQC becomes relevant. You know, depending on what the company is doing, will depend on whether you need to be CQC registered, and it's something that you will have to keep an eye on. So it might not be that you need to be CQC registered at the outset, and the reason for that is you're not, as a company, providing a regulated activity, and that's the key thing that you're looking. Is it that this company is providing regulated activity or not? If it isn't, then you don't need to be CQC registered. If it is, then you will. And as I said, it's something that you likely have to keep monitoring as and when you're looking to change the way in which the company is going to develop and what it's going to do. But it's just something, hence why it's in a bit of a pink box there as opposed to the other ones there. So that's effectively all we had. It's quite a whistle-stop tour around some of the core considerations and incorporation. If there are any questions, please do fire away. I know there was some in the Q&A box, but if there are any, we're happy to take those.
So just Rob, just in terms, if we can just go back to that slide, Harry. In terms of the timing of this process, are there any sort of comments around how long this process can take?
Well, I mean, I think you have to bear in mind probably more as well. It's going to depend on whether you're going to go for CQC registration, to be honest. I think that's the biggest draw on time. Our experience is if you are actually going to go for CQC registration and looking to set this up to actually deliver a service, you'll be looking at between a 5 to 6 month period. And the reason for that is you've got to front end all the work around agreeing what the articles look like, the shareholders agreement, and then incorporating. And it's only once that incorporation takes place that you can then make the applications to NHS pensions and then also to CQC. With CQC, they're running on, I think the last I heard was a 14-week turnaround in terms of the applications.
Okay. I mean, I think the other issue we're seeing from an accounting viewpoint is that pensions determination process. in that is a point of delay as well, because the pensions determination, you've got to apply for two types of determination, what's called an open and a closed basis, which is all done at the same time, which allows you to transfer people in, but also employ future people, unnamed going forward. The issue at the moment is I think they've got quite a few applications ongoing, and they are taking several months to turn that round and get it approved. So I think from a PCN perspective, we got a couple of points there where actually it's totally out of your control as to how quickly this can take, which is why it's quite important really that the initial work up front, again, practices can, or PCNs can make that decision on the shareholders agreement around the structures of the shares relatively quickly, because that gets through that bit of the process and into the process where you can't actually control it, which is quite important. So someone else has also asked just now, with only 18 months until the end of the current PCN DES, will the limited company be helpful for a relatively short period of time? Good question. It's a difficult one to answer from our perspective, because we just don't know what's going to come. I mean, all I can guess is, looking ahead, is that more and more when we look at some of the ICB stuff that's coming out, it's all focused around PCNs. And in terms of where investment is going to come, it's not going to come at practice level, it's going to come at larger entity level, which at the moment for general practice looks at PCN level. So PCNs in there, will have to continue, I guess, going forward, but whether they look exactly as they do today is I guess, a bit of an unknown. Rob, do you have any comments on that?
No, I think that's absolutely right. So, they've just put in place integrated care boards, and the whole ICS structure works on the basis of those three levels. So, system, place, and neighbourhood, and PCNs, quite fortuitously fall within the neighbourhood level. So, undoubtedly, the way in which they're hoping to commission and really drive through at scale provision at neighbourhood level is via some form of PCN-esque vehicle. Now, whether that will be the same as what we're looking at now, but again, it's a bit crystal ball. But I think in direct answer to the question is yes, there's 18 months left on the DES. But again, actually beyond the DES, if we're looking beyond the DES, will this do other things? Can we see the value in this doing other things within the locality as well? Because I think, we will see PCNs continue in one way, shape or form. We don't know the exact sort of direction of travel that will be taken, but you will get a sense of what it could do or potentially do for the actual individual practices now, and that is likely to extend over the end of the 5-year DES initial period.
Yeah. I think the other thing I would say is that actually some of the issues that we've talked about are happening now. Again, from a purely financial viewpoint, that VAT issue is totally happening at the moment, and you have to have a solution around that if you're not going to incorporate. And sometimes the solution just isn't there, because actually it's not very straightforward to get around. So some of those issues do need to be got round in the last 18 months of the current sort of PCN window. So yeah, it's difficult. It's quite a big leap to go forward with this type of thing, but it does solve some of the problems. Okay. So another general question, which is just a more general question. Different uplifts applied to ARS staff versus practice GMS staff is causing potential pressure on pay awards, and different uplifts. Any comment how to navigate this? Yeah, it's difficult. I had, I was in discussion with one practice a few months ago, really, and their PCN staff were employed via a federation, and the federation had given them a 6% uplift in their pay, and those staff were sort of sitting in practices next to other members of staff who had a 2% uplift in pay. It's pay generally at the moment is a massive problem. It's not just a problem in the health service. It can assure you it's a problem in legal practice and accounting practices as well, with where inflation is at the moment. Again, it's really around the fact that in some cases there's not a lot you can do, because if those members of staff are covered by certain parts of a pay agreement nationally, then you have to follow it. It really is a case, well, it's a case of really just trying to manage the process at the moment as best as possible, which is not a great answer to give you, unfortunately, but it's just a difficult problem at the moment with inflation being as it is.
And I don't think there's a legal answer really that can be given to that, to be fair. You know, as you said, Andy, if you're following national regimes in terms of pay, then they have to be followed. It's just, I think the difficulty here is what there is then there's visibility of what others are being paid, whereas historically there wouldn't necessarily be visibility of what these other staff would be paying in different roles.
Okay. Brilliant. So just move on the slide, Harry, and I'll just wrap up. So yeah, thank you for everyone who's joined us today. Hopefully we covered some of the issues in the short time available, and maybe some of the solutions, but just highlighted some of the problems available to you. If you need to contact us, our contact details are on screen there. We will be sharing a link of this video out to people that have signed up in the near future. So if you've not been able to, or want to watch it again or share it with your colleagues, then please do. Hopefully that's found it useful. As I said, our next session is a week today, and we will be looking at practice merger issues. So slightly different from today, but some similar issues about how to scale up general practice. So thank you again for your time.